I'll call the meeting to order. We'll start off with the Pledge of Allegiance. And ma'am, if you're going to testify, I'm going to have to swear everybody in, so if you'll raise your right hand, I'll swear all of you in. Do you all swear from the testimony you're about to give us the truth, the whole truth, and nothing but the truth? Thank you.
I kept my hand down this time, sir.
For the benefit of our one respondent, my name is Drew Smith. I'm the Code Enforcement Special Magistrate. I am an independent. I'm a lawyer practicing 20 years in local government law and code enforcement. My role here is to be an independent fact finder. I'm not an employee of the city. They retain me for the sole purpose of being an independent fact finder in these cases. The way each case will proceed is you'll see the code enforcement officer already at the podium now. Code enforcement will present each of the cases as we go through. When the code enforcement officer for your case is done, you'll have an opportunity to ask the code enforcement officer any questions you would like to ask about the case and present to me any evidence, testimony you would like me to hear. And when I've heard all the evidence, received all the evidence, heard all the testimony, I will enter a verbal ruling today. That ruling will be followed in the mail by a written order. Okay? Thank you. And clerk, you can call our first case.
Case number 2022-1199, Juan Antonio Amado Velasquez, owner, Ruiz Sumika Bonet, owner, location 1420 Kentucky Avenue, St. Cloud, Florida.
Good afternoon, Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 1420 Kentucky Avenue. At this time, I would like to enter into evidence the following items: copy of the courtesy notice, copy of the notice violation, copy of the notice violation sent by certified mail, copy of the statement of violation notice of hearing sent by certified mail, copy of the PowerPoint presentation, evidence of mailings, copy of the deed to the property, copy of the code sections in violation, copy of the costs incurred if the special magistrate finds the respondent in the violation in the amount of $229.14.
Thank you.
On July 18th, 2022, while on a routine patrol, I noticed an above-ground pool was installed without a permit in the rear yard at this location. On July 19th, a courtesy notice was sent to the owner. On August 3rd, a reinspection was performed, and the pool was still there with no permit. I took one photo. On August 4th, a notice violation was sent to the owner. On August 19th, the reinspection was performed, and a permit was applied for and in review until August 25th. On August 29th, a reinspection was performed, and the permit had been disapproved on August 25th because the pool dimensions and the setbacks needed to be added on the survey. On August 30th, a notice violation was sent by certified mail to the owner explaining that the permit had been disapproved on August 25th and why it had been disapproved. On September 19th, reinspection was performed and the permit was still disapproved. I took one photo. On September 20th, a statement of violation notice of hearing was sent by certified mail to the owner. On October 7th, a reinspection was performed and the permit was still disapproved. I took a photo. On October 18th, the reinspection was performed. The permit was still disapproved. I took one more photo. The respondent is not here. It is the city's recommendation that the respondent be found in violation of allowing an above-ground pool to be installed prior to obtaining a permit at this location. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $229.14 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
And no respondent on this case?
No.
Have you had any communication with the respondents?
One time, and I explained, and
And they understood?
mm-hmm.
And they do reside at the property, right?
Yes, sir.
I'm guessing the hurricane blew down the canopy?
No, well, it was just kind of, it wasn't even really a canopy. It was just kind of a
Jury-rigged?
little bit of shade thing, yeah.
That was the reason why I was asking if it was occupied, because it looks like it's sitting down in the pool now and they haven't fixed it. Okay, based on the evidence testimony received, I'll find in favor of the city. Find the respondents are in violation of city code for allowing an above-ground pool to be installed prior to obtaining a permit. order the respondent to cure the violation by either obtaining the permit or removing the above-ground pool by November 1st, 2022. If not brought into compliance by that date, a fine in the amount of $100 per day shall accrue for each day beyond November 1st that the property remains in non-compliance. We'll also order the respondent to pay the administrative costs incurred by the city in prosecuting the case in the amount of $229.14, which amount will be due within 7 days of the date of my written order.
Thank you.
Case number 2022-1200, Justina Devlin, owner, location of violation 1404 Kentucky Avenue, St. Cloud, Florida.
Good afternoon, Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 1404 Kentucky Avenue. At this time, I would like to enter into evidence the following items: copy of the courtesy notice, copy of the notice of violation, copy of the notice of violation sent by certified mail, copy of the statement of violation, notice of hearing sent by certified mail, copy of the PowerPoint presentation, copy of the affidavit of posting, evidence of mailings, copy of the deed to the property, copy of the code sections in violation, a copy of the costs incurred if the special magistrate finds a respondent in violation in the amount of $242.18. On July 18th, 2022, while on routine patrol, I noticed an above-ground pool was installed without a permit in the rear yard at this location. On July 19th, a courtesy notice was sent to the owner. On August 3rd, a reinspection was performed, and the pool was still there with no permit, and I took one photo. On August 4th, a notice violation was sent to the owner. On August 19th, a reinspection was performed, and there was still no permit. On August 22nd, a notice violation was sent by certified mail to the owner. On September 7th, a reinspection was performed, and there was still no permit. I took one photo. On September 14th, a reinspection was performed, and there was still no permit. The owner called and asked for more time to get all the paperwork together to submit for the permit. And I took one photo. On September 21st and September 27th, re-inspections were performed, and there was still no permit applied for. I took one photo on the 21st. On October 3rd, a statement of violation and notice of hearing was sent by certified mail to the owner and posted on the property and City Hall. An affidavit of posting was completed. I took two photos. On October 18th, the re-inspection was performed, and the pool was still there with no permit applied for. I took one photo. And the respondent is here for this property. It is the city's recommendation that the respondent be found in violation of allowing an above-ground pool to be installed prior to obtaining a permit at this location. The city would like to also recover the costs incurred in bringing this case before the magistrate in the amount of $242.18 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
One question for you before you hand the podium over. On your statement of fees,
Yes, sir.
you've got $242.14 as the total.
Okay,
Yeah, math, that's what it looks
Yeah.
like. I wanted to give you the opportunity, if it was 242.18, not that it matters for the 4 cents, but if there was something other than a math error, I wanted to
No, it's
draw it to
just-
your attention. Okay, then I'll use the 242.14 number.
Okay.
Okay, anything else from code enforcement?
That's it, thank you.
Respondent?
Step to the podium, tell them, give them your name.
Your name?
Hello, my name's Justina. I had told her that I had submitted my application. She had told me she didn't see it on her end, so I went back and checked on the application. They said I needed to have my yard surveyed, so I submitted that paperwork. And so I turned in the application the other day. Previously, it was missing, they said it was all set, and that is what I told her, but she said it was too late because she had already processed the paperwork. They told me it was all set, and they'd email me with the billing amount, and like a week later, they sent me an email stating I need to update my survey.
And this communication with the city was going on when?
They emailed, I have an email from them.
When, or about when was that email?
I know it was during the hurricane,
Okay,
around
so
the
beyond
hurricane.
July 19th.
Yeah, yeah.
Okay,
Yeah,
because what code enforcement has presented is that you are now in compliance.
Yeah, I asked her for an extended, for an extension, and within that time, I went and, applied for the permit. And they said I was all set, and they'd email me with a bill. I never received the bill, and that's when I got the code enforcement on my front lawn. And then I got the survey in I got an email saying I'm missing, my yard needs to be surveyed. So I just bought my house last November. I know nothing about any of this stuff. So I went through all my paperwork, and I have proof of the yard was surveyed last November or something, or whatever, October. And so they said I just need to put a dot in the dimensions. I'm nervous. I don't
It's
like
okay.
this stuff. So I just submitted that like a week ago.
Well, from the code enforcement standpoint, as far as the violation that you were initially cited for, you have cured that based on what's been presented to me tonight.
No,
so-
sir.
No?
No, I said as of
Permit yet.
the 18th, there was no permit yet.
Oh,
That's yes.
No permit was even applied for. I
Okay.
didn't see anything.
okay, so when do you want this cured by?
Oh, I forgot to put the date for compliance. Okay, my bad. Sorry.
That's okay.
November 1st is what I would put.
Okay, so then what they're asking is for a November 1st compliance date. And you say you've submitted all of the paperwork?
Yeah, I have the email of, from them. I meant to get proof, but
That's okay.
yeah, the paperwork submitted. They told me I was all set.
And so you're just waiting to have the permit in hand?
Yeah, the permit, and then they said I owed them money because I faxed them something, so they need
And
to
so,
bill me for that.
So when you come to pick up that permit, you will have to pay the permit fee.
Yeah, whatever that
And so
is.
assuming that is done by November 1, then you will be in compliance. Do you foresee any problems getting the last couple steps done by November 1st?
No, as long as they have all the information, which they said they did.
Okay. Okay, so then I will find that the respondent is in violation of the cited code section, order the respondent to cure that violation by obtaining the permit by November 1. If you have any issues with that, if you hear back from the city, contact the code enforcement officer and let her know what's going on, that you're on top of it.
Okay.
And the code enforcement has asked for payment of administrative costs, the amount of $242.14. Because this is a violation, I am going to enter the award of costs to the city. Normally, that would be, as you heard in the last case, within 7 days of the date of my order. Does that create any hardship for you to pay the $242.14 within 7 days? I'm almost always open to more time if somebody gives me a good reason to need more time.
I mean, there's no way to avoid paying the $240.
It is
I've been in compliance as
It's the
I've
cost
asked
of
her for more
prosecution, and that's why I was
time.
curious when this correspondence was going on, because this case started in July 19th is when you received the first notice.
Yeah, and then I asked her for an extension,
November
and then
now.
I called her recently and asked her why we have to go to court.
Right, it sounds like those conversations started about the time that you got a notice of hearing.
Yeah, once I seen
Had
code,
you
because
acted
I
on the
thought I was in
notice of violation within the time that was allowed in the notice of violation, and actually in St. Cloud, and this is I'll say this because it strikes me, in St. Cloud, you actually get several notices of violation before they start scheduling a hearing. In most jurisdictions, it's one notice of violation. So you had multiple opportunities to cure this before it got to that point. And every time they have to go out and perform an inspection, every time they have to send a letter, it is costing the city money. And the reason why the statutes authorize us to enter costs is so the taxpayers don't have to pay the cost of prosecution of somebody who didn't do what they needed to do when they first got the letter.
And I asked her if we could avoid going to court, and she said it was too late. She already submitted the paperwork. But I had told her on my end, I had the,
This
they
is all
told me my
occurring in
app,
October.
huh?
Based on what you've already testified, that's all occurring in October. In July and in August, you got a letter that said cure by this date. Had you cured it then, had you picked up the phone and called her then to cure it, none of the other next steps would have happened. She wouldn't have had to spend that time that results in those costs.
and I asked her for an extension.
When you got the notice of hearing. I'm talking about the notice of violation you received in July.
Okay, then,
So back to my initial question, is there a hardship in paying that within 7 days? Would you like more time?
yes, please.
Okay. How is November 1? Same date that your compliance date would be.
I don't understand the question.
All right, is there?
You
is it-
asked me if I needed more time. I said yes.
And is November 1, because there's a compliance date of November 1, I will use that. If you want more time than November 1, how much time do you need to?
As much time as you can give me.
How's
I
30?
just had 52 cents in my bank account, and I had to take the day off for today.
Okay.
So as much time as you can give me. This is why I asked her to avoid going to court, and this is why I've asked for plenty of extensions.
Then I will give you 60 days. Does that work?
Thank you.
Okay.
Case number 2022-1356, SFR JV2 property owners. Location of violation, 4487 Baylor Trailer Drive, St. Cloud, Florida. Trails Drive.
Good afternoon, April Bennett, Code Enforcement Officer for the City of St. Cloud. I'm presenting this case for the property located at 4487 Baylor Trails Drive. At this time, I would like to enter into evidence the following items. Copy of the courtesy notices sent by regular mail. Copy of the notices of violation sent by regular mail. Copy of the notice of violation sent by certified mail, posted on the property and City Hall. Copy of the statement of violation and notice of hearing sent by certified mail, posted on the property and City Hall. Copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $221.60. And they are not here. On August 3rd, 2022, during routine patrol, I observed high grass and weeds at this location. During the research to write up that violation, I noticed that this was a rental property. I was able to confirm that there was not an active landlord license. On August 4th, 2022, I sent out a courtesy notice by regular mail to the owner of record. On August 17th, a reinspection was performed and the violation for the high grass and weeds was corrected. However, there was not a landlord license on file. On August 19th, I sent out a notice of violation by regular mail to the owner of record and to the registered agent. On August 29th, a reinspection was performed and the violation was not corrected. They sent out notice of violation by certified mail to the owner of record. A certified mail was received and it was signed for on September 6th. On September 14th, a reinspection was performed and the violation was not corrected. On September 19th, I sent out a statement of violation, notice of hearing by certified mail, posted the property in City Hall, and did an affidavit of posting and took 2 photos. On September 21st, I spoke to a representative from the property management company for this location. She advised that they were unaware that St. Cloud required licensing for rental properties. On September 22nd, I emailed the property management company a copy of the BTR landlord application to be completed. On October 5th, it was brought to my attention that I had made an error in the description of violation on the statement of violation and notice of hearing. I corrected the error and sent out an updated statement of violation and notice of hearing by certified mail, posted the property in City Hall, did an affidavit of posting, and I took 1 photo. On September 17th, 2022, a reinspection was completed and the violation was not corrected. It is the city's recommendation that the respondent be found in violation of not having a landlord license for the property at this location and not corrected by the time specified. The city would like to give the respondent until November 21st, 2022 to correct the violation or pay a fine in the amount of $100 a day until compliance is met. I have spoke to via email to the company and they have assured me that they had sent in the license. The Planning and Zoning Department is backed up on mailings right now because of BTR season, so it possibly could be sitting downstairs. That's why I'm allowing some extended time on that. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $221.60 be paid within 7 days of the written order by the special magistrate. This concludes my presentation.
You, not so much the evidence of the case, you've carried your burden of proof, but I want to make sure that when I prepare the order, I am using the correct legal description. So the amended statement of violation and notice of hearing, where was the error?
It was in the description of number, I believe it's number 4. I had left in there,
A description of violation.
right, I had left in there something about a right-of-way obstruction, and it was only for a landlord license, so I had to correct that section.
Okay. Okay. So the obstruction of the right-of-way is,
It was for a different case. I accidentally
part of this
copied and
case.
pasted
Got
that in there.
okay, that, let me fix it. Based on the evidence testimony received, I'll find in favor of the city, find that the respondent is in violation of city code for not obtaining landlord license and BTR within the time required. Order the respondent to cure the violation by obtaining that permit and license by November 21, 2022. If not obtained by that date, a fine in the amount of $100 per day will begin to accrue and continue to accrue until compliance is met. Also order the respondent to pay the administrative costs incurred by the city in the amount of $221.60, which amount will be due within 7 days of the date of my written order.
Thank you.
Case number 2022-1442, Brian C. Luther, owner. Location of violation, 4724 Lake Trudy Drive, St. Cloud, Florida.
Good afternoon, Melissa Howells, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence a copy of the following items. A copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail posted on the property in City Hall, a copy of the statement of violation and notice of hearing sent by certified mail posted on the property in City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, a copy of the deeds of the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $258.14. The respondent is not here. On August 17th, 2022, I received a complaint that there were several abandoned vehicles at this location in High Grass. I went by this property and verified 2 abandoned vehicles, a black BMW car with no tag on it and a black Saab that appeared inoperable due to the growth around the vehicle. And I could tell it hadn't moved in quite some time. The grass was high in the side and rear yard. I took 6 photos while I was there.
So this picture set, which vehicles am I paying attention to?
Okay, I'm sorry. Let's go back then. There's the BMW. There's no tag on that one. And then the black Saab is that car there that's in the weeds. And it's backed up to the weeds, but you could tell it hadn't moved in a long time.
Okay.
On August 18th, I sent out a notice of violation by regular mail to the owner of record and the name and utilities to correct the grass violation within 7 working days and the abandoned vehicles within 10 working days. On August 30th, a reinspection was performed and the violations were not corrected. I had been receiving several complaints in the meantime since the first notice was issued. 12 photos were taken.
Property's occupied, right?
Oh, yeah. On August 31st, I sent out a notice of violation by certified mail to the owner of record, posted the property in City Hall, did an affidavit of posting, and took 3 photos. On September 12th, I checked the property to see if the grass violation was corrected, and some of the yard was mowed, however, not the rear or the side yard. 7 photos were taken.
Front yard was completely mowed though.
Yeah, the front yard was mowed.
That's the sob.
Yeah,
the
I don't know why I took that on the 12th, but I did anyway. Because I went back on September 15th and to check for the abandoned vehicle violation, and the black Saab was pulled forward, but the tire was dug in the ground, still making the vehicle appear to me to be inoperable, and the black BMW still did not have a current tag on it. 10 photos were taken. And you can see that one hasn't moved, the BMW. But the Saab was pulled forward. But you can see the tires dug into the ground. On September 20th, I verified the violations were not corrected. On September 21st, I sent out a statement of violation and notice of hearing by certified mail to the owner of record. I posted the property in City Hall, did an affidavit of posting, and took 10 more photos. On October the 10th, I was in the area and just noted that compliance had not been met on either violation. On October 17th, an inspection was performed for today's magistrate meeting, and the violations had not been corrected.
Any improvement?
No. 8 photos were taken showing noncompliance. They put some furniture up. I don't know why they thought that would hide the grass, but I don't know. Anyway, there's the BMW. The Saab is still in the same spot with the dirt. Excuse me. There's the BMW. And he moved the trailer to where you can't see the weeds as much on the side yard, but they're still there. Later in the day on the 17th, the owner did call me and wanted to know what needed to be done because he could not be at the meeting. From what I gathered, the son lives at this location. I advised him that all the vehicles needed to have current tags on them and operable, and the grass and weeds needed to be cut in the rear and the side yard. I also let him know that the findings of facts would come by certified mail, letting him know what the outcome of the meeting was. It is the city's recommendation that the respondent be found in violation of having high grass and weeds and abandoned vehicles at this location by the time specified. The city would also like to give the respondent until November 1st, 2022 to correct the violations or pay a fine in the amount of $100 a day until compliance is met. The city would also request the costs incurred in bringing this case before the magistrate in the amount of $258.14 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Based on the evidence testimony presented, I'll find the respondent is in violation for high grass and weeds and abandoned or inoperable vehicles parked on the subject property. Order the respondent to cure those violations by November 1, 2022. If not brought into compliance by that date, a fine in the amount of $100 per day will accrue until compliance is met. Also order the respondent to pay the administrative costs incurred by the city in the amount of $258.14, which amount will be due within 7 days of the date of my order. I do have a question for you.
Sure.
If you can go back to the lawn furniture that was stacked up, maybe to hide the, I know this is not a cited violation and I'm not entering an order related to it, but it appears to me that that could be a prosecutable junk and debris case.
It could be, yeah.
Do you have any objection to me just including the note that while it's not part of this case and I am not ordering them to do anything related to that, that for their benefit, they may want to go ahead and clean that up now before they get another citation?
Yes, sir. That would be great. Thank you.
I will do it.
Case number 2022-1466, Samik Enterprises LLC owner, location of violation 4577-4589 13th Street, St. Cloud, Florida.
Melissa Howes again, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, a copy of the statement of violation and notice of hearing sent by certified mail, posted on the property and City Hall, a copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $220.14, and the respondent is not here.
Thank you.
On August 22nd, 2022, during routine patrol, I observed the required fence around the dumpster area falling apart and not being maintained at this commercial location. There was also a lot of trash around the dumpster, and code enforcement has had issues with this particular dumpster in the past. On August 23rd, I sent out a notice of violation to the owner and registered agent to correct these violations within 10 working days. On September the 9th, a reinspection was performed and none of the violations had been corrected. I took 6 photos showing the violations.
Is this commercial or residential property?
Commercial. I don't know if you can see it, but the fence is falling down the bush. The weeds are pushing the fence out. I tried to get it at different angles for you. That's from the rear. That same day, September the 9th, I sent out a notice of violation by certified mail to the owner of record and registered agent, which was signed for on September the 16th. On October the 4th, a reinspection was performed and the violations were not corrected. 9 photos were taken. On October the 5th, a statement of violation and notice of hearing was sent to the owner and registered agent by certified mail, posted on the property and City Hall. 2 photos were taken. I was just showing where I posted it in front of the plaza. On October 11th, I was in the...
Just one
Okay,
question
go ahead.
before you go on, before I forget to ask it. Is that dumpster serving the entire plaza, or is it just serving a portion of the plaza?
The entire plaza.
Okay.
On October 11th, I happened to be in the area and noticed that the fence was being taken down, and I could see just how much trash and debris was around the dumpster, so I took 4 photographs. So all of that was behind the dumpster. And I know I couldn't zoom in and show you exactly what was back there without trespassing. And I don't know if I would be trespassing since the city dumpster, but it definitely is full of trash and debris. And then they even had a trailer there full of bagged up trash.
Does the city collect, or is that private collection?
City. And that's what happens, is we've had complaints in the past because the dump trucks have gone in there to pick them up. And when they go to put them back, because all the debris falls down, they can't place the dumpster back where it's supposed to go. And we've written several throughout the city, and it seems like it's the same ones that junk them up over and over. On October 17th, an inspection was performed for an update for today's magistrate meeting, and most of the fence is put back up, but there is a lot of garbage in and around the dumpster. 4 photos were taken. So they started replacing the fence. Some of it is old panel, but there still is no gate on it, so I'm not putting that into compliance yet. And like I said, there's still trash all over. I mean, I think it's the owner's responsibility to get with their tenants and make sure that they're keeping that maintained, or they hire a company to come in and do it. I've had no correspondence at all from the owner of this property. It is the city's recommendation that the respondent be found in violation of having an accumulation of rubbish and garbage around the dumpster and not maintaining the required fence around the dumpster area within the time specified. The city would like to give the respondent until November 1st, 2022 to come in to correct all the violations or pay a fine in the amount of $100 a day until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $220.14 be paid within 7 days of the written order of the special magistrate. And that concludes my presentation.
Based on the evidence testimony presented, I'll find in favor of the city, find the respondent is in violation for allowing accumulation of rubbish and garbage around the dumpster, and also for not maintaining the fence that surrounds the dumpster. I do find the respondent has begun repairs, but those repairs have not been completed, and my order will reference that. I will order the respondent to cure the violations on or before November 1st, 2022. If not brought into compliance by that date, a fine in the amount of $100 per day will accrue until compliance is met. Also order the respondent to pay the administrative costs incurred by the city in prosecuting the case in the amount of $220.14, which amount will be due within 7 days of the date of my written order.
Thank you again, sir.
Case number 2022-1559, Arlene Franklin Signs Jr. Estate Owner. Jennifer Baker, tenant. Location of violation, 2001 Pine Street, St. Cloud, Florida.
Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 2001 Pine Street. At this time, I would like to enter into evidence the following items: a copy of the notice violation sent to the owner and the tenant, copy of the notice violation sent by certified mail to the owner and the tenant, copy of the notice violation with the new date sent to the owner and posted on the property and City Hall, copy of the statement of violation, notice of hearing sent by certified mail to the owner and the tenant and posted on the property and City Hall, copy of the affidavits of postings, a copy of the PowerPoint presentation, evidence of mailings, copy of the deed to the property, copy of the code section in violation, copy of the costs incurred if the special magistrate finds the respondent in violation in the amount of $274.78. On October 3rd, a reinspection, flipped one too many
Ahead of
pages.
yourself.
I know I did, right? On October 30th, 2022, while on routine patrol, I noticed the grass and weeds were high at this
What was that
location.
date?
What's that?
August 30th.
Didn't, I meant August 30th.
Okay, got you. Now
Today's not
now
my
we're
day, I don't. I know.
with you now.
On August 31st, a notice violation was sent to the owner and the tenant. On September 13th, the reinspection was performed and the grass and weeds were not mowed. I took 3 photos. On September 14th, the notice violation was sent by certified mail to the owner and the tenant. On September 26th, a reinspection was performed and the grass and weeds were not mowed. I took 2 photos. On September 27th, a notice violation with the new date was sent to the owner and posted on the property and City Hall. An affidavit of posting was completed. I took 3 more photos. On October 3rd, a reinspection was performed. The grass and weeds were not mowed. On October 4th, a statement of violation notice of hearing was sent by certified mail to the owner and the tenant and posted on the property and City Hall. The affidavit of posting was completed, and I took 3 photos.
Is it just the back and sides, or is it the front also?
It's parts in the front. Like around, like they have like bushes and stuff, and it's around that really high too. On October 10th, a reinspection was performed. The grass and weeds were not mowed. I took 2 more photos. That's in the back. And that's down the side. On October 18th, the reinspection was performed. The grass and weeds were still high around the fence. They mowed everything, but it was around the fence, and I took 2 photos. And we've had issues with this house before, and they seem to come into compliance like right before the time. The respondent is not here. It is the city's recommendation that the respondent be found in violation of allowing high grass and weeds to be above the height of 8 inches at this location, and to have the grass and weeds mowed around the fence by November 1st or pay a fine of $100 a day until compliance is met. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $274.78 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Do you have any communication with the tenant?
No, and
Have you heard, I mean, this time or other times, have you had any communication from the estate?
no. And the first time I posted it with the certified, I put it up on their door, and then when I went back, they had the fence where I couldn't go through, they had it zip tied. So I couldn't even knock on the door.
I have on a previous case, do you, Derek?
It doesn't, it's not gonna make a difference in my ruling, but I was
Right.
trying to think if there's any way I can get
Okay.
through to them, they need to maintain this property.
Okay, so the last time that this was, that I had cited this property, which wasn't long before her, I had spoken to the granddaughter, who is the Jennifer Baker.
The tenant is the granddaughter?
Yes, the grandmother is in a assisted living home. She has pretty much taken over the property, and I had the same issue. She would mow a little portion here, a little portion there. I ended up having to post her. She did finally come into compliance at the last minute, but it seems like every single time she pushes it to the limit on not weed eating anything.
Do you know that, is she doing the lawn work herself, or is she using somebody?
I have no
I
idea.
didn't think you would, okay. Just trying to think if there's any angle I can word things in the order to maybe get a little bit more attention. I'm gonna find in favor of the city, find the respondents are in violation for allowing the grass and weeds to grow to a height in excess of 8 inches. Order the respondent to cure the violation by November 1, 2022. I will recognize the respondent has made progress, but will point out to them that they have not cured the violation. I will stress the importance of keeping the grass mowed. If they do not bring it into compliance by November 1, 2022, I will order a fine of $100 per day to accrue until compliance is met. Also will order the respondents to pay the administrative costs incurred by the city in the amount of $274.78, which amount will be due within 7 days of the date of my written order.
Thank you.
Anything else from code enforcement? I have one question, and this may be an IT question. Is this room set up for Zoom? Do you know?
No, I don't believe it is.
It's not?
I mean, Jay can answer.
That's why I said it might be an IT question.
I don't believe it.
The reason not that it matters to me much, but I was in a hearing, Judge Perkins in Flagler County, he is doing his hearings, I guess, exclusively through Zoom now. We had everybody, the deputy, the attorneys, the clerk, everybody was live, and I didn't realize he was appearing by Zoom at all of his hearings. But it got the thought thinking, because I have this terror sometimes, what if I get sick on code enforcement day? What do we do? And so I was thinking, well, if this room was set up for Zoom, then I could always say, look, I cannot be there today because I'm sick, but then I could still appear by Zoom, and you would not have to cancel hearings. So that's the reason why I was asking.
Room Zoomable. The technology isn't the issue, but apparently the issue is that we were only allowed to do.
Yeah, the public meetings, and so I hadn't thought that through yet, and I don't think it applies to me, but I don't know. But it was just that's the only reason why I was asking was I always have that in the back of my head is what happens if I would hate to be sick, to fall sick on code enforcement morning and have to call you guys and say, I can't be there.
Right. Well, I believe the city clerk could check on that.
Yeah, well, hopefully it never comes to pass, but it at least would give us an option if that were to come into play, so.
We can do it.
So technologically, it's practical if it's legal, and that, I hadn't thought that hard about it. It seemed like if judges can do it, we can do it, but I know we're under different sets of rules. But thank you, everybody. If there's nothing else, then we are adjourned.
Jack.
Oh, I know you would, and I know, it happens to all of us, but I always, if I wake up with a
Jack,
scratchy throat,
You
I'm
don't
like,
have
uh-oh.
anything on that? You don't have anything on that? Like, you don't know anything on that?